Hello, my name is Tony Westbrooks. I'm an estate planning, Medicaid planning, and probate attorney and owner of Formula Law located here in St. Louis, Missouri. And I just received an interesting call from a potential new client who, unfortunately, his son had recently passed away. And he had called his attorney who had drafted his current estate plan to see if any changes needed to be made to his plan, if it needed to be amended, just, what did he need to do now that his son passed away? And he, upon visiting with the attorney that had created his estate plan, after they had had a chance to look through his estate plan, he was quoted a fee anywhere between $5,000 and $10,000. And his gut was telling him that that was much more than he was anticipating, and he decided to get a second opinion. I was not provided a copy of his estate planning documents, and so I could not make a legal determination of what kind of work potentially needed to be done to amend his estate plan now that his son was no longer with us. So I was not able to give him advice regarding any particular changes that need to be made. However, I gave him the advice that he should go with his gut. And I think that's a rule for anyone who is seeking an attorney to draft an estate plan or even amend or change an estate plan or a will or a trust or a power of attorney, is that if something just doesn't feel right with the attorney that you are meeting with, it is perfectly okay to seek out the opinion of a second attorney. And again, I've been drafting and amending estate planning documents for almost 17 years at this point, and I had taken for granted that that my clients were bringing me documents that were previously drafted by other attorneys, whether or not they were in Missouri or other states. And I had taken for granted that I knew that I had the authority or that I could amend or change documents drafted by another attorney. So my client, or the caller, asked if I could amend documents created by another attorney, and certainly the answer is yes. That the attorney that initially drafted your estate plan does not have to be the attorney you always use forever and ever. You could certainly have a second attorney draft an amendment or draft an entirely new plan. And it kind of brings up another situation that I encountered too, where it was actually a family member who had had a long-term relationship with an estate planning attorney and got himself set up in an annual kind of payment plan where he would pay a fee to this attorney every year. And then upon his passing, when I had a chance to review his entire estate plan, I noticed that his trust had been restated 3-4 times, and that we were on the 14th amendment of my family member's trust. And it seemed excessive. It seemed a lot. I wish that he had gotten another opinion from a second estate planning attorney to see if all of the changes made to his trust were necessary. I think it would have saved him a lot of time and energy that he spent over the last 14 years of his life updating his estate plan. So, ultimately I say go with your gut, and you can always use more than one estate planning attorney over the course of your family's estate plan drafting and amendment period. So, ultimately, if you would like to discuss changes to your estate plan, to your will, to your trust, to your powers of attorney, please do not hesitate to book a call. I can be reached at www.formulalawoffice.com, where you can book a 30-minute complimentary initial call with my firm, or give me a call at area code 314-798-69 877-888-7875. Thank you very much. Bye-bye.